Single bench, item 1.
Division.
Division bench, item 1. Review petition 184/19.
In this case, Lordship, we are supposed to file affidavit, Lordship. So, Lordship, it could not file, Lordship.
It's a 2020 matter.
Yes, Lordship. Can it be after 2 weeks or 3 weeks, Lordship?
In fact,
That may be
2019.
fixed, Lordship.
No, my brother will not be available. So December first week.
Lordship.
December first week. You're fixing it on 3rd
3rd December.
3rd December.
Lordship.
But don't fail this time.
So that point that don't fail, but this petitioner is under suspension. Man. He's
Huh?
not getting any allowance. Man. Two petitioners. Man. They're government employee. Man. Anyway, my lord, your lordship, because
So we'll make it very clear. Mr. H.R.A. Chaudhary, Learned Senior Counsel, assisted by Mr. A.M. Ahmed, Counsel, Learned Counsel for the petitioner, submits that there is some urgency in the matter as the petitioner,
1 and 2 are grade 4 government employee.
petitioner numbers 1 and 2 are government employees and they are currently under suspension
They're not getting subsidy allowance also.
and they are not getting subsistence allowance as because as per opinion of the Learned Foreigners Tribunal, they have been declared to be a foreigner of post 25/3/1971 scheme. Next paragraph.
Although his other family members' name appear in the NRC. Man.
That's okay.
That already your lordship lost.
All the respondents are represented. Mr. G. Sharma Lanet, Standing Counsel for the Home Department. Has prayed for an adjournment, seeking some more time to file affidavit in the matter. Next paragraph, we made it clear that in view of the submission made by the Learned Senior Counsel for the petitioner, if the affidavit in opposition is not filed within 30/11/2024, the matter would be heard on the basis of materials available on record. Next para. The Learned Standing Counsel for the Home Department shall transmit a downloaded copy of this order to the concerned respondent authorities to bring the order to their notice. List on 3/12/2024.
Interim order may complain.
Okay, interim order passed earlier stands extended till the next day. What is the interim order?
Interim not to be reported.
Stands extended. Interim order passed earlier of not deporting the petitioner without order of the court stands extended till further orders.
All right.
I may appeal also. Milot item number 32, Milot. 32. Abdul Salam, final.
You want an adjournment?
Only for the day, Milot.
Okay, but it goes for a week.
32.
Both sides are represented. List after a week as prayed for by the Learned Counsel for the petitioner. Yes.
Maybe I like to mention first minor correction in date, my lord, only in item number
Item 8.
13(1)(3), my lord. Only date correction. Date maybe
1/3.
1(3), my lord.
Okay, give it to him. 1/3. No correction. Okay.
Maybe, Your Lordship. I like to mention item number 19 and 22, my lord. Maybe take it after 2 weeks, my lord. Item 19 and 22.
After 2 weeks,
Yes, my lord.
1922.
Yes.
Same order. Yes.
Then, no, I think it's been. It may be faster for the day, my lord. Well, we have some personal problem.
18 after a week.
Must.
Okay.
May I please, Lordship, I back to mention item 30, Lordship.
33.
Yes, Lordship. The engage comes to MA monthly out of assistance. Can we attend for something?
Okay. After 1 week or 2 weeks?
Okay, 2 weeks.
33.
Yes, sir.
2 weeks.
Interim will continue.
There's no interim. There's maybe only bail. For bail, we don't have to give an extension.
Actually, Lordship, I beg to mention item number 34, Lordship.
34.
Item we adjourn for the day.
After a week.
Lordship.
Upgraded item 42 for orders.
Yes. Nobody's there. This is regular rate appeal. This is for regular rate appeal. Usual course.
Upgraded item 43.
Yes, you filed an affidavit.
Yes, Lordship, I have filed the affidavit.
It's not come.
Upon record.
Has it come?
Upon record? ঘটনাখনে ফাইল করতো লাস্ট we check if it's on record.
Filing number to say.
File number four, yeah.
When did you file it? When did you file it?
I filed on the last occasion the case was listed. The date I forgot to Lordship. The Lordship on 4th of November. 4th of November. ঘটনাখনে last list is it? Five days.
Filing number to.
Let it be listed along with affidavit, Lordship. Not all affidavit or copy.
Please check if it is not there.
You have to check the record when you file the affidavit if it has come or not.
Please check up, it is not there.
Lordship will look it up along with the affidavit, Lordship, because even we do not have a copy of the affidavit.
Uh, Is as it had the counsel for the applicant has submitted that an affidavit in terms of order dated 4/11/2024 has been filed. Full stop. Now the same is not on record. Full stop. The registry shall examine and tag this as affidavit on record. List on Monday, we make it.
Yes.
List on 18/11/2024.
Organize.
Please check up.
Organize.
Item, supply item 48.
May I please, your lordship? Present order is lordship page 41. This original tribunal decision is the ex party order.
Yes, what is the
Lordships, here is the
what
case.
is the explanation?
Explanation, lordship. After the tribunal's orders, I filed an application for review of the order of the tribunal, lordship. That is page, that was also dismissed, page 39A. That application is page 38A, lordships. Round I have taken 38A page. Paragraph number downs here taken, lordship, paragraph number 8, 9, and 10, lordship, page 38D and E, lordship, will find of my review application. That was filed under order 9 rule 13, reduced 150 on the CPC, that application. A review which is not dismissed on 27/9/2016, that is page 39A.
Hmm? Right.
One opportunity may be given. My mother's names also appeared, the NRC details of
So this, you see,
2008.
there's a default.
Yes,
There's a
some
default
default
to
was-
receive notice through your nephew.
nephew
After that, you take a plea that the uh, proceedings was transferred to the Forest Tribunal number 2.
lordship.
Now, once you have notice and then you don't appear, for that there is no explanation.
My sister's husband appeared on behalf of me, lordship, filed the application. But here is also reflected and Wakalatnama was also filed. But so far in respect of Wakalatnama, lordship, that is dated 10/3/2014, and notice issued, lordship, it was 2/7/2014. That is also in doubt, lordship. And I got information after that they are poor person, lordships. They are staying Delhi. They are
Pardon
collecting
me?
broken articles, step collector, lordships, article.
No, but once
that
you
income they are-
intentionally don't appear,
One
once you
opportunity, I have sufficient documents. Other family members have no case also, lordship, and their names also appear in the NRC details of recent, lordship, 2009. All have been appeared, lordship, except me because of the case, lordship. With any condition, one opportunity, lordship, I am paying that. And the tribunal also passed, lordship, only on the basis of police report. What has the report, lordship? That also not been reflected. What are the report collected, that whether I am the.
no, because anything
The-
that's happening is
every
within
burden
your
against me, lordship.
anything which is happening is within your family. You
Yes.
got information, then you say there's a blame game. You say that the sister's husband did not inform my husband. Those things.
He tried to contact me, did not found because, lordship, in the
Then-
review petition, it was mentioned that, but after
After
coming to,
after
after
inquiry,
coming from Delhi, lordship,
after inquiry, you
immediately
must
took steps, lordship.
after inquiry you must inform the authorities about your address. You don't give. Notice is served to your family member. You don't appear.
Lordship. That time petitioner was residing at Delhi, lordship. This is the problem, they did not get contact, and after coming back from Delhi, lordship, immediately took steps. And review petition also filed, that it was dismissed, that came before this court. Then it was dismissed, lordships, and they
Yeah.
went for honorable apex court, lordship. That honorable apex
don't-
allowed me to withdraw, to file a review application on that
No,
matter.
that is on your request. But you have to still satisfy.
Lordship, one opportunity, lordship, a reasonable opportunity may be given. That what are the, and apart from that, it was not decided on merit also, lordship. Only on that I have not appeared.
You.
Any condition, lordship, if I will not be defaulted in the event of allowing this review. I have sufficient documents, lordship, in my parents, family. Even I have a school certificate, lordship. My father's name, grandfather's name, Bhutas, 66, 70. Father's name.
You see, Mr. Bhavya, we are exercising review jurisdiction. You'll have to show us something more for exercise of review jurisdiction. It can't be for asking.
Yes, Lordship. But only one point, Lordship. Both the tribunal and this court, Lordship, did not decide the case on merit also, Lordship. Apart from that, only discussing that I have not appeared, Lordship. But what are the documents collected against me, Lordship, that I am a foreigner also?
Yes, Mr. Sharma.
Lordship, everything has been discussed in the High Court order, Lordship, and in the review jurisdiction, Lordship, Lordship may not rehear the matter in the guise of review jurisdiction, Lordship. Lordship, and there are so many decisions, Lordship, and already delay has been occurred, Lordship, in this case, Lordship. And prisoner is remained silent, Lordship, since more than 4 years, Lordship. After that, he approached the Supreme Court by withdrawing the said petition and come before this honorable court, Lordship. Lordship,
Yes,
2022 SCC online 1034, Lordship.
please give again. 20.
2022 SCC online SC 1034. Para 18, Lordship.
What does it say?
Para 18, Lordship, after discussion, it was stated that, Lordship, a glance at the aforesaid provisions makes it clear that
What is the name of the parties?
as Madhusudan Reddy versus V. Narayana Reddy and others. Lordship, a glance at the aforesaid provisions makes it clear that a review application would be maintainable on discovery of new and important matters or evidence which, after exercise of due diligence, were not within the knowledge of the applicant or could not be produced by him when the decree was passed or the order made, on account of some mistake or error apparent on the face of the record, for any other sufficient reason. That was maintained, and Lordship, and para 19 also important, Lordship. Para 19, it was stated that in Colonel Laboratories in Second versus Union of India, this could observe that a review of an earlier order cannot be done unless the court is satisfied that a material error, which is manifest on the face of the error, would result in miscarriage of justice or undermine its soundness. The observations made as under a review is not a routine procedure. Here we resolve to hear the couple at length to remove any feeling that the party has been heard without being heard. But we cannot review our earlier order unless satisfied that material error manifest on the face of the order undermines its soundness or results in miscarriage of justice. In Su Sandra Kante versus Sheikh Habib, this court observed a review of a judgment is a serious step and reluctant resort to it is proper only where a glaring omission or patent mistake or like grave error has crept in earlier by judicial fallibility. The present stage is not a virgin ground but review of an earlier order which has the normal feature of finality. And Lordship, there was another case, Lordship. Lordship, another case is Lordship may not kindly noted, Lordship 2013 8 SCC 320. 2013 8 SCC 320, Lordship.
Yes. Name of the party is?
Kamalesh Burma versus Mayawati and others. Lordship.
Yes.
Lordship, I am relying para 20, Lordship. Para 20.1, Lordship. I am reading para 20.2. I am relying whole para 20, Lordship. I am just now reading para 20.2. When the review will not be maintainable. A repetition of old and overall
That is
argument.
paragraph?
Para 20, Lordship.
20.2.
Yes.
I am reading para 20.2, Lordship. When the review will not be maintainable. A repetition of old and overall argument is not enough to reopen concluded adjudications. Minor mistakes of inconsequential import. Review proceedings cannot be equated with the original hearing of the case. Review is not maintainable unless the material error manifest on the face of the order undermines its soundness or results in miscarriage of justice. A review is by no means an appeal in disguise whereby an erroneous decision is reheard and corrected but lies only for the patent error. The mere possibility of two views on the subject cannot be a ground for review. The error apparent on the face of the record should not be an error which has to be fished out and searched. The appreciation of evidence on record is fully within the domain of the appellate court. It cannot be permitted to be advanced in the review petition. A review is not maintainable when the same relief sought at the time of arguing the main matter had been negatived. Various result, yes, absolutely. ইয়াতে আছে নেকি এই ৰিভিউৰ এটা judgment আছে।
Mr. Bobby, anything in reply?
Lordship, I am relying upon the decisions of the Honorable Supreme Court Lordship 1993 Supplementary 4 SCC 595.
Please come again.
1993 Supplementary
1996.
93 Supplementary 4 SCC 595. There's so many parties. The first was S. Nagaraj and others. Was the state of Karnataka and other related case also. That is paragraph 18, Lordship, may I read? Paragraph 18, 1-8.
Yes.
May I read, Lordship? Justice, a virtue which transcends all barriers. Neither the rules of procedure for technicalities of law can stand in its way. The order of the court should not be prejudicial to anyone. Rule of stare decisis is adhered for consistency, but it is not inflexible in administrative law as in public law. Even the law bans report justice. Entire concept of real jurisdiction exercised by the higher courts is founded on equity and fairness. If the court finds that the order was passed under a mistake, or it would not have exercised the jurisdiction, but for erroneous assumption, which in fact did not exist, and this perpetration shall result in miscarriage of justice, that it cannot on any principle of precluded from rectifying the error. Mistake is accepted as valid reason to recall an order. Difference lies in the nature of mistake and scope of rectification, depending on if it is a fact or law. But the root from which the power flows is the anxiety to avoid injustice. It is neither statutory or inherent. The latter is available where the mistake is of the court. In administrative law, the scope is still wider. Technicalities apart, if the court is satisfied of the injustice, then it is its constitutional and legal obligation to set it right by recalling its order. Here, as explained, the bench of which one of us was a member did commit an error in placing all the stipendiary graduates in the scale of first division assistance due to stage failure to bring correct facts on record, but that obviously cannot stand in the way of the court correcting its mistakes. Such inequitable consequences as have surfaced now due to vague affidavit filed by the state cannot be permitted. Then paragraph 19, reviewing literally and even judicially means re-examination or reconsideration. Basic philosophy inherent, it is the universal acceptance of human fallibility. Yet, in the realm of law, the courts and even the statutes lean strongly in favor of nullity of decision legally and properly made. Exceptions both statutorily and judicially have been carved out to correct accidental mistake or miscarriage of justice, even when there was no statutory provisions and no rules were framed by the highest
92 supplementary 4 SCC. 92 supplementary 4 SCC. 595.
93 supplementary.
93.
93 supplementary.
93 supplementary 4 SCC. 595. Yes. It-
আছে নেকি 74 আছে তো safety। সেভেন্টি ফোর
Other judgment lordships, 2005 4 SCC
2000
5 4 SCC
4 SCC
741. Parties Board of Control for Cricket, India, versus Netaji Cricket Club.
এই হার্ড কপি টু নিয়ে দিলে প্লেস
2005 4 SCC
Lordship
741.
741.
তুমি একটু রেফার করে দিও 15 পেজেস আছে তো লাইন নিদিব পাৰি তুমি যে কোলাই মান রেফার করে দিই আপা হেল্প করে দিও
ডিলেন অ্যাক্সেসর লিখে পড়ছে
তোমাক সব আছে আগে নকো লেখা দিলে ম্যাচেস মি লিখা আছে yes itu lah diলে ম্যাচেস 2009 1 SCC 768 no like 2009 itu mo কি বল
একটু একটু দেখুন মুখ দিয়ে উপর দিকে
Yes. Which paragraph?
Paragraph lordship 89, order 47 rule 1. She got it.
Yes.
Order 47 rule 1 of the court provides for filing an application for review. Such an application review would be maintainable not only upon discovery of a new and important piece of evidence, or when there exists an error apparent on the face of record, but also if the same is necessitated on account of some mistake or for any other sufficient reasons. Then paragraph 90. Thus, a mistake on the part of the court which would include a mistake in the nature of the undertaking may also call for review of the order. An application for review would also be maintainable if there exists sufficient reason therefore. What would constitute sufficient reason would depend on the facts and circumstances of the case. The word sufficient reasons in Order 47, Rule 1 of the Code is wide enough to include a misconception of fact or law by a court or even an advocate. An application for review may be necessitated by way of invoking the doctrine actus curiae reminam gravity. Then paragraph 91. It is true that in more and more baseless so and so case, the court made observation as regard limitations in the application for reviews. Before going the merits of the case, it is well to bear in mind the scope of the application for review, which has given rise to the present appeal. It is needless to emphasize that scope and applications for review is much more restricted than that of an appeal under the provision in the Travancore Code of Civil Procedure, which is similar in terms of Order 47 will want our Code of Civil Procedure 1908. The Code of Review has only a limited jurisdiction circumscribed by the definite limits fixed by the language that used therein. It may allow a review on 3 specified grounds, namely discovery of new and important matter or evidence which, after the exercise of due diligence, was not with the applicant's knowledge or could not be produced by him at the time when the decree was passed. Mistake or error appear on the face of the record or for any other sufficient reason. It has been held by the Judicial Committee that the words any other sufficient reasons must mean a reason sufficient on grounds, at least analogous to those specified in the rule. Then 92. Yet again, in Lily Thomas Supra, this court was laid down the law in the following terms. Paragraph 52, by referring to paragraph 52 of that case, Lordship. The dictionary meaning of the word review is the act of looking, offering something again with a view to correction or improvement. It cannot be denied that a review is the creation of a statute. This court in Patel Mercy, Takeshi versus so AIR 1970, Supreme Court 73 held that the power of review is not an inherent power. It must be conferred by law, either specifically or by necessary implication. The review is also not an appeal in disguise. It cannot be denied.
This
that
is
the-
not required for your purpose.
that this is not Lordship. The first one is very important, Lordship.
Okay.
1993. That here is the case, Lordship. All the family members are Indian, except me. And that's in the vocal number, Lordship, that time, instead we are in Delhi or something. Thereafter, we take immediately steps, Lordship. And having sufficient documents are one opportunity of Lordship. Even in the tribunal judgment, it will find what are the grounds, Lordship, that I am also putting. That
We'll-
is not reflected.
We'll consider
in
and
the-
pass orders.
Lordship, another aspect is there, Lordship. Delay aspect, Lordship. Delay, Lordship. Delay and laches, Lordship. Already, Lordship, our High Court also did not accept the petition in respect of delay, inordinate delay, Lordship, was not accepted by this honorable court, Lordship.
No, you
Regarding,
see, there we just a moment. B117. B117. This is 21. Okay. Okay, we take note of your submission.
yes, Lordship, review petition 74 of 2018, Lordship.
This is under his jurisdiction, Lordship.
Review petition, Lordship.
Review is
Okay.
this one
74 of
provision
2000
does judgment
and
I
under-
have also, Lordship.
Under judgment is, Lordship,
Not
civil appeal
required
number
appeal.
5027 of 2024, Mrinmoy Meiti.
Civil appeal.
Yes, Lordship. 5027 of 2024. Special leave petition. Civil number 30152 of 2018, Lordship. It
What-
was
what is-
decided
What is the name of the parties?
Mrinmoy Meiti, Lordship. MRINMOY MAITY.
Just a moment. 5027 of 2018.
5027 of 2018, Lordship. 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 5027 of 2018,
Mrinmoy,
Maity, M-A-I-T-Y,
Maity.
yes, Lordship, versus Sanda Kole and others, C-H-H-A-N-D-A. N-D-A. Kole, K-O-L-E-Y and others. Okay. Para 12, 13, Lordship. 12, 13. As well as 14, Lordship.
Okay.
Lordship, one, as per submission by Lord Mayor, I am relying upon the decisions of this honorable court, Lordship, 2002 GLR regarding the
Give a
review.
copy. Give a
Yes,
copy of that.
Lordship. More detail.
Okay. We'll pass orders in chambers. We'll
Yes, sir.
deliberate and pass orders.
Yes.
Yes.
Forty-nine.
Like,
Yes, you're filing affidavit.
Lordship, I have filed an affidavit.
Hmm?
I have filed an affidavit, Lordship.
You filed it.
Additional
It's not
affidavit.
come on record. Oh, yes, it has come.
Lordship. Detail to give a decision. Fixing not the order, I have. Copy সার্চ করেছি
Ms. Verma, we are accepting that affidavit and giving 7 days time more to appear and take bail.
Lordship, she never appeared and only after she was arrested, she's before this court. Lordship may notice may go at this point, Lordship.
You have taken that, but
Lordship, when they do not appear and they are arrested, they are very prompt to come. But when police goes looking for them, they are not to be found, Lordship.
correct. You are right.
23 order, I think my friend is referring to a order of 23. She never appeared before the,
Before that, she did not appear. She was apprehended and only thereafter this came.
and only after she's arrested, she's before this court, Lordship.
But she was arrested on 2/9, almost 2 months.
After Lordship had asked us, Lordship, after that
Correct, correct.
came out, it is only after that
Correct.
it has been taken up, Lordship.
Okay, taking note that she is a lady, we are releasing her with conditions. But Mr. A. Diwan, Planet Counsel for the petitioner, applicant. Also heard CGC was there.
Mr. S.S. Roy.
Mr. S.S. Roy, also heard Mr. S.S. Roy on CGC for response number 1. Mr. Ms. A. Verma, and standing also for the Home Department representing the respondent number 2 and 4. Mr. R. Taludar and Committee Advocate appearing for respondent number 3. And Mr. T. Pegu, learned counsel appearing on behalf of Mr. A. Ali, standing counsel for respondent number 5. There is no representation from respondent number 6. Pursuant to opinion dated 4/10/2017, passed by the learned member, Foreigners Tribunal, Borpeta 10th, Bajali, in FT case number 84 of 2015, the petitioner was taken into custody on 2/9/2024. Next, brother. In this interlocutory application, it is projected that by an order dated 15/12/2023, passed by this court in the connected WPC 1151 of 2023, this court had granted conditional bail to the petitioner by directing the petitioner to appear before the Superintendent of Police within Packet Border, Bajali, on or before 30/12/2023 during the office hours and furnish a bail bond of ₹5,000 on conditions as stated therein. Moreover, it was also provided that in the event of failure on part of the petitioner to comply with the directions, the bail granted to the petitioner shall stand automatically vacated, and she shall be liable to be taken back into custody. Full stop. Next, it is not in dispute that the petitioner had defaulted in appearing before the Superintendent of Police within Packet Border to proprietor and to take bail. And therefore, as there was no bail order operating, the authorities had no option but to arrest the petitioner and sent to detention camp at Matia Gwalpara. Matia, Gwalpara. Next one. Next, by filing this interlocutory application, the petitioner is seeking release from the detention camp. Next paragraph. Pursuant to order dated 6/11/2024, the applicant the applicant's son, namely RAIZ, next one, Uddin, has filed an additional affidavit and they were undertaking that he has taken full responsibility to communicate the orders to the petitioner for future compliance. And he has provided his mobile number 7364913831, for which he can be communicated. Next paragraph. The learned standing counsel for the Home Department has opposed the prayer for bail on the ground that it has taken a lot of effort by the authorities to track and apprehend the petitioner. And it is submitted that in the event the petitioner is granted bail, there is every likelihood that she may abscond. Next one. The ground disclosed by the petitioner for not taking bail in terms of order dated 15/12/2023 passed in the connected writ petition does not is too vague and not acceptable. Nonetheless, on a project on considering that the petitioner is a lady and projects herself to be 54 years of age, and on consideration that the petitioner was apprehended on 2/9/2024 and is under detention for more than 2 months. The court is inclined to extend the time for granting bail to the petitioner. extend the time granted in order dated 15/12/2023 passed by this court in a connected WBC 1151 of 2023 for the petitioner to take bail by providing as follows. Next paragraph. A, that the family members of the petitioner shall produce a certified copy of this order before the Superintendent of Police within bracket border bracket close Bajali during office hours of the working day. Full stop. Next paragraph B, on receipt of the certified copy of the order of this order, comma, the Superintendent of Police shall do the needful for releasing the, for accepting the bail bond to be submitted by the petitioner in terms of the order dated 15/12/2023. On being satisfied with the bond as well as the surety offered. Next paragraph. Before releasing the petitioner on bail, comma, the Superintendent of Police within bracket border, comma, Bajali shall do the needful in terms of directions contained in the order dated 15/12/2023 passed in the connected WBC 1151 of 2023. And only thereafter allow the petitioner to be released from the detention camp. It's called detention camp. I always forget detention camp, Komamati at Golpara. First of the same shall be done within three working days from the date of receipt of certificate copy of this order. This application stands allowed and disposed of. I should just give one more condition there. I have given one ABCD, then one more at there, that the petitioner is directed not to leave the territorial jurisdiction of the Superintendent of Police within bracket border Bajali without prior written intimation to the said authority.
Deep obligations, much.
Okay. What is about the council?
Daily list item 1 for motion.
Right, please, Your Lordship.
Yes.
That imprint opinion is at page 41. That is dated 17/7/2018.
Yes. Do you have any document where your
Document,
name is
but
reflected with your father, apart
Yes.
from voter list?
Voter list, one exhibit two, Lordship. That to exhibit one is the landability receipt of my grandfather who was residing under the Gauripur Raj estate as the tenant, Lordship. That was exhibited. That that is page 16.
No, but how do you connect yourself to your
Yes,
father and
that's
grandfather?
why, Lordship.
Except for
Yes,
Except for voters list, what is
Yes.
the other document you have?
an exhibit to Kosara Goalpara Tenancy Act, that is my father's and uncle's name reflected, that is dated 5/2/1961. I have annexed as exhibit page annexed to page 18. That was exhibit 2. And connecting exhibit 2, that exhibit 366 of my uncle's name, that is page 20. Kalu Sheikh is my uncle. I have specifically stated in my written statement also. That's lordship, exhibit 2, page 18.
No, you see, there must be some other document to connect you apart from voters list.
Yes, sir.
How do you connect that?
The
That
connect lordship.
Kalu is your,
Here, lordship, notice
Is your-
issued, my father's name shows lordship Kalu Sheikh. Nalu Sheikh. That prior to.
no, but that name is not there because in page 19, it is Kalu Mandal.
Yes,
Then again in your voters list, which you are showing is Kalu Mok. Because it doesn't match. That's why we're asking you.
page 18 lordships, Kalu Mandal, Nalu Mandal.
That's why we are asking you. Is
Yes,
there any
lordship.
document apart from voters list to connect you to your father and grandfather?
Lordships, that voter list 1966, page 20.
No, except for voters list. Voters
Except
we
the
are-
voter, these are two documents, exhibit 2 and 3, and my evidence and written statement. And state also did not controverted. Nobody appeared also, neither examined. My evidence is very much clear. The written statement clearly stated. The written statement is page 32, clarifying the mining, page 32. And here, apart from that, lordships,
What is the name of your father?
my father's name is lordships Nalu Sheikh, alias Nalu Mandal. And one of, against him, lordships, a case was registered. It was stated in my requisition that was that time pending. Today, I have no information regarding the two contact number provided to us that are found not in order. What was the present position? I am not aware of that father's case also. After the delivery of the opinion, lordship, that case was pending. That notice I have father's lordship in that, and I have stated in my requisition also. That will help in the present case, lordship, if my learner will call for information from that case, lordships. What happened in my father's case? The two numbers they provide were not found in order, lordship. And here the evidence is very much clear, lordship, not denied documents, not controverted also. And state also not appeared in the state case also. So I discharged my burden, lordship. Only difference found on Kalu Mandal, that's about. But the residence address, everything are incorrect. There is no controversy. They have not controverted. They also not challenge my documents also. Because since they have not appeared also, state. In this regard, lordship, there was earlier occasion, I placed judgment of the recent judgment lordship on our FS code, lordship. They recently decided 2024 that Rohim Ali case.
You've seen the records?
Regarding discrepancies of name, I will place the 2-3 distance of this all course and on a request of later distance. Wait a second. Okay, so.
Which page is the opinion?
Lordship,
Which page is the opinion?
opinion is page 41, Lordship. Okay. Lordship's tribunal held that since reference my father's name mentioned Nalu Sheikh, but documents I produced Nalu Mondal. So difference name appears. But written statement I specifically stated, clarified, the Nalu Sheikh and Nalu Mondal is same, Kalu Sheikh Kalu is same. And regarding descriptive names, Lordships of
Look at your cross examination. You say that I don't know the contents of any of the documents. everything is washed off.
Lordship. Prosecution has not appeared. For tribunal question.
So appearance is
But-
not required.
No,
Appearance is not
tribunal
required.
questioned.
In which case, you have seen government appearing? Government is omnipresent. It will be there everywhere.
Here says that none appears. Judgment reflected.
That's okay.
Nobody appeared, and they have not.
That's okay. Have
they
you not
have-
heard of any writ petition being dismissed without issuance of notice?
No, Lordship, certainly not.
Then
Here is the case, Lordship.
a suit being dismissed without
they
appearance
have
of the
not-
respondents.
They have not disputed my documents,
No,
not controverted. Regarding
It's your
distribution,
burden, Mr. Barbia.
Yes,
Don't take us
I-
back to those,
Section
all these, so many judgments where it has been laid down that it is your burden under section 9. Question of dispute, where does it arise?
if they dispute Lordship, that's but what is their case? I am the foreigner, Lordship. What is the
No,
document they
please tell
relied
us.
upon?
No, please tell us.
Yes.
In a case, you move a writ petition.
Lordship,
The respondents have not been even issued notice.
Lordship,
You don't find merit in the writ petition and dismiss it.
yes, yes,
Correct.
Lordship.
Now, in this case also, nobody disputed the documents. Nobody disputed the statements. We were just not satisfied and dismissed it. Now, what is wrong about it? What is so shocking
what
to the
are the-
conscience?
That findings is correct or not, that should be looked into, Lordship.
No, please tell us. You see, in your cross-examination, you say, I don't know the contents of the documents which I filed.
That because
What
I am
more do you want?
illiterate.
What more do you
unable to
want?
read, he stated I am illiterate.
No. What more do you want?
That's
Under the
whatever-
Evidence Act, does it say that the illiterate person without knowing the contents of the document can prove it?
someone had to explain, Lordship, what are
No,
these
you
are
have the,
written-
you see,
explained
Mr.
by
Bhavnia,
Assamese, Lordship, what-
we have our limitations. In the bench, we have limitations. But there you don't have limitations. You can still go and stand in the election, win, and change the law.
regarding Lordship.
Become a law minister.
Lordship,
But we are bound by the procedures.
but
Please tell us under the
Lordship,
under the legal system.
even Lordship, my submission is that since father's case, I have in the repression I have stated and notice I have my father's that was pending at that point of time when the opinion was delivered. And that information whether what happened that case, 2 numbers provided that is not found. Lordship, I may provide the case, the notice of my father, Lordship.
This matter,
That-
Lordship.
And
His
if the
father's
father
case is,
If father becomes an Indian citizen,
yes,
then
become Indian citizen, that's
but
the question.
that is his
Abdul Quddus,
you tell us, we give you 1 week's time to
Lordship,
tell us.
Lordship.
Lordship,
find out.
No, Lordship,
I
we
tried,
will not
Lordship, did
find out.
not
Let
find.
him find it out
Because-
himself.
case
you have
number
to
I
wait.
am providing.
No,
We'll
Lordship,
have to
we
wait.
cannot do all this.
We cannot.
We are not going to act as a postman for him, Lordship.
My learned friend 2 times tried also.
Myself, served the number and I contacted the local people. But they took some time to.
No, you see, we'll give you 1 week's time. But
Even-
but-
Lordship, apart from that, he has no case. The land documents he's referring to, Lordship, that
That are
Asra
90 years
is-
old document.
was obtained only in
That yes,
2015.
the section 90 the evidence that there is
No,
no
please,
dispute.
please don't
Example-
interact. You are not responding to everything she is
Like-
saying.
Yes.
When you are arguing, when you are submitting, she did not
No,
disturb you.
I am not
Please
disputing.
don't disturb anybody who's making submissions.
So I am sorry.
In his written statement, he writes, he has written that the land was mutated and the records are there, but during the time the opinion was passed, he has not produced any document mutation certificate supported by the report of the circle officer.
We reserve a comment when we take it up because are you aware this document is under which is issued under which act? Are you aware of it?
GT Act, Lordship.
You're not aware of it. That's why.
And other
Many
documents-
many of you, except for I think Mr. Das would know, sitting behind you. Others would not know it. This is Gwalpara Tenancy Act. Gwalpara Tenancy Act, you may not know even. It's 1920. It is 1929.
19.
So Mr. Das may have some experience. He will know about it, but others may not Many of,
His own statements.
no, that's okay.
say-
We reserve our comments. We give you 1 week's time
Lordship.
since we have already heard it.
That notice, father's notice, I have my learned friend even contact from that tribunal.
No, we won't bother her.
Lordship, all right, Lordship.
We won't bother.
Lordship will fix a date.
All sides are duly represented. On the prayer made by Mr. F. Barboya and counsel for the petitioner, the matter stands adjourned today. List of today is 13th. This one 27/11/2024. We are
Yes.
giving 2 weeks time.
Lordship.
We'll take a short break and come back.
Certificate. Two and three is voter list of 65 and 70. And the fourth one is Jamabandi of his father, my lord. Well, the learned tribunal rejected the evidence of Gambura only because the certificate issued by him contained the national emblem. That is thing, my lord. And the second thing is, my lord, the learned tribunal rejected all other evidence because the petitioner has failed to file any link document. So rejected all the evidence.
So that is why we are also asking the same thing. How do you connect yourself to your parents and projected grandparents? That's the link document we want. What is the best document to connect you?
But my lord, one thing I'm saying, he has got a school certificate and that school certificate is authenticated by the inspector of school of Nagaon. Another thing is there, my lord, he has got a Jamabandi which shows that he is the son of his
Shows
father.
that Jamabandi. Where is
and
that copy?
His name was mutated along with his brother sister as legal of his
Where
father.
is the Jamabandi? Which page?
That Jamabandi is my lord at page 16.
16. That was exhibited.
It was not exhibited, my lord. These 4 documents are not exhibited. So my submission, my lord, before your lordship, that these documents should be allowed to be proved in the tribunal, my lord, by remanding the case. Because link document it is correct that link document was not produced in the lower court. But link documents are the school certificate and the Jamabandi, my lord.
Where is the school certificate?
Records of right of government.
Where is the school certificate?
School
Where is the school certificate?
certificate, page 12, my lord.
Because Mr. Das,
Yeah.
this Jamabandi which you are relying is at page 17, right?
Yes, sir.
Yes, sir.
Yes, page 17. You see, in page 17, this certified copy was obtained on 27/9/2018.
Yes, my lord.
So that means this document,
His father was alive, my lord, after his.
no,
That's
that's okay. But page 17 shows that the certified copy you are holding since 27/9/2018. There's a ticket on that court fee stamps. The date is given. Page 17, court fee stamp, the date says. That means the document was available with you, but you did not prove it.
Yes, my lord.
But this document was available with you. That means the condition precedent for additional evidence is not there.
But my lord, his father possessed land from before, from his father also inherited his land from his grandfather. And that Jamabandi is, my lord, at page 13, annexure 3.
একটু প্লেস করা নাই বলেই কইছিল।
Here also you see this was a pre-existing document, 13/7/16.
Yes, ma'am.
This is certified copy is obtained on 13/7/16. That means
So
you
then-
had the
then-
documents and did not prove it.
17/9/18, my lord.
No, 17, 13. It is 13 SMS. 13/7/2016
Yes, ma'am.
is SMS.
I think lordship, it was exhibited lordship. Page 4.
Exhibit 4. So
Exhibit
this was
4.
proved. Exhibit 4.
Yes, lordship.
Okay. Exhibit 4, which is the entry of your father or grandfather? What is the name of your father or grandfather?
Abdul Rahman.
Muslim Uddin,
But then something is wrong. Something is wrong in this page 14. Which is the, in the remark column, which is the entry you are relying on? Page 14,
Yes, my lord.
which is the relevant remark on which you are relying on?
lordship, page 17, lordship, vernacular.
No, 14, 15, this is the end. So in 14 and 15, there must be some entry on which Mr. Das is relying,
Yes, my lord.
which is the relevant entry.
But Muslimuddin is the father and his name is at serial number 8, my lord.
Serial number 8,
Yes, my lord.
Muslimuddin Pita
Serial
Rahman.
number 8.
A. Rahman gets the land by way of purchase lordship in the year of 1972.
Where do you get it? That's what you are searching.
Yes, lordship, ক মন্তব্য ক
Oh. 22/3/75 হাইকোর্ট হুকুম মতে এবং দেবত শ্রী আব্দুল রহমান লগত শ্রী রমেশ উদ্দিনের নাম। So this is post
71.
71 document. And where is that 66 voter list?
Page 22.
For 65 voter is at page 22, my lord. And 70 is 23.
But Mr. B.C. Das, learned counsel for the petitioner. Also heard Mr. S.S. Roy, learned CC appearing for respondent number 1. Mr. G. Sharma, learned standing counsel for the Home Department, representing respondent number
2 and 4.
2 and 4, and Mr. G. Pegu, D. Pegu, T. Tripura. Yes. T. Pegu, learned counsel appearing on behalf of Mr. A. Ali, standing counsel for respondent number 6. So there is no representation. You said none appeared on call for respondent number 3. Next paragraph. Page 38. If your opinion dated so and so, past bench also is held in this retribution file under Article 226 of 226 of the Constitution of India, comma, by which, full stop, by the said opinion, the petitioner was declared to be a foreigner or post 25/3/1971 stream. Issue notice. Extra copies within 2 days. Let the concerned, let the relevant records be requisitioned from the concerned tribunal. The petitioner shall appear before the SP border, Superintendent of Police border, which place? Nagaon, within 10 days and take bill 5,000. Failure of the petitioner to take bail within the time allowed, the order of bail shall stand lapse by afflicts of time, at least after 4 weeks on receipt of records. 10 days time to take bail, otherwise it will be revoked. Yes, 2 to 4.
The lordship, kindly the measure will be taken after some time.
After some time.
Yes, lordship.
Okay.
Five.
Yes, Mr. Siddhar, what is the best document?
My lord, admittedly, my lord, parents are voter in 1971 only. No 66 voter list. My lord, page 33.
And any other document to link you to your parents?
My lord, no direct linkage, but my brother, who is voter with parents, he was examined as DW2.
Which page?
My lord, lordship may kindly see the voter list first, my lord, with 47.
It's okay, we take your word for it.
My lord.
Where is the cross examination?
My lord, at page 69, my lord.
69.
69, DW2. My name is Abdul Salam. My father's name is late Kalum Sheikh. I am resident of village Zorsmuli Gospota, Moses also. Today I have come to give evidence for OP. She is my elder sister. I am well versed with the statement of my affidavit. The engaged counsel has read out all the statements of my affidavit in my native language. To prove my birth and place, I have submitted voter ID and the certified copies of the voter list of 1966. 17, my lord, there may be some wrong recording in 66. There is no 66 voter list. My lord, so far my lord understanding in the judgment, my lord. 71 is there, 77, 85, 89, 93, 97, 2005, 2010, 18 are there, my lord. I cannot say my date of birth. I do not know the OP's date of birth. She is about 10 years older than me.
Doesn't appear that this witness is a part of the family.
My lord, part of the family.
Doesn't appear.
my lord, my date of birth, how these people.
No, not
can-
that he doesn't even know when the parents were born. It's something which every son and daughter will know where from they come. If they're a happy family, they will at least
My
know.
lord,
I don't think you can stand up and say that I don't know where my parents are from.
my lord, my understanding and these people, whoever remote or village illiterate, my lord, they only.
No, Mr. Mr. Sikdar, you are far more busy with no time. With that
They-
amount of matters you have, the amount of work you do, you don't have time. Maybe you don't have time to discuss with your children, but still, can somebody in the family come and say that, well, I don't know, my father does not have time, therefore I don't know where he was born, what he's doing.
My lord, with due respect, my lord, I agree with your lordship, my lord. But these people, my lord, these remote or people, my lord, illiterate, my lord, they are very careless about their all these things, my lord. They are only know how to work, my lord, for their livelihood. Some excuse they deserve, my lord. My lord, otherwise he is voter with his.
Okay, we'll call for the records.
No, my lord.
Okay. Okay, we give that consideration, but merit we don't find anything.
My lord, if we see, my lord, there, my lord, body language, my lord, we sometimes become so hard against them, my lord. That is a fact, my lord. But what we can do, my lord?
You know, my experience would be different. I have seen many sharp people who appear to be knowing nothing. They will be more inquisitive. They will hear more and then say less. And please believe me when I tell you, I have seen very sharp people, the people who are at the very top. I've seen those people, they hardly interact, as if they don't know anything. But very successful people. Few days back, while traveling, I found a girl. She was not interacting. She was sitting beside me in the flight. And for some reason, during course of interaction, I could come to know that she is a financial management. And one of my relatives is also a very good financial manager. So with that connection, I realized that this girl who was not speaking anything, not interacting, she has a very high profile financial, what do you call,
I think that ego problem is.
she's worth much higher than you can think of. A very young girl from Guwahati. She was much worth you can think of. So that's how I've seen people.
Impugn order, lords will find at page 85.
Mr. A.R. Sigdat and Counsel for the Petitioner. Respondents are same. One is CGC, 2 and 4. Home Department, and then, Mr. Sharma. Government is, respondent number 3 is Mr. Talukdar. And 5, Ms. P. Barwad, standing also for respondent 5, is none appears on call for respondent number 6. Opinion, where is the opinion, which page?
Well, at page 85.
Opinion dated 25/1/2024, passed by so and so and so and so. Say what, notice bail to the satisfaction of
Well, SPB Borpata.
SP Border Borpeta. appear before 10 days, within 10
My-
days.
my-
Take bail, 5,000.
Deep level.
Failing which the bail would be revoked.
Item 6.
Item 6, Lordship, we are supposed to place the LCR, Lordship. I have the LCR, Lordship, but at 2, Lordship, I can place it, Lordship.
Okay.
Or Lordship, tomorrow, Lordship may fix.
Let it be today because this thing is again a very
Yes, yes,
difficult
Lord.
job. So by the time I rise and sign, it's always 6:30. So these people have to work hard.
Lordship. It is 2 PM.
At two. If we ultimately can't take it up, then we adjourn it, but may not be tomorrow. We'll fix some other day. Some other day.
Lordship, I have the LCR, but
Okay. Then we take it up at 2. We'll try to
Yes.
take it up.
Item 7.
Wait, your lordship.
Yes.
Lordship, petitioner is declared foreigner.
Yes. You start from where we left on 6th.
Lordship, the evidence, DW1, DW2 and DW3 deposed before a tribunal. DW1 is Hussein DW2 is maternal uncle of the petitioner, and DW3 is the
How do you connect them with your father and your maternal uncle? How do you relate with them?
Lordship, my mother stays with her paternal home, Lordship. So the address, my address is the same with my maternal grandfather, Lordship.
Okay, what is the document?
Birth certificate, Lordship, Annexure 9, page number 58. Yeah, my father is Sanmia, Lordship. My mother, my mother married twice, Lordship. His first husband was Yasin Ali, who died after her marriage, crossing 5 years of marriage. Thereafter, she married with Sanmia, with my father, Lordship.
This birth certificate which you are showing is not exhibited document. Was it exhibited? Hmm?
Birth certificate is exhibited, Lordship. Exhibit A,
Exhibit A.
page number 54, Lordship.
List of documents are নাই কিন্তু opinion ত আছে voting documents তো মোৰ পৰা নাই 84
Thereafter, Lordship, voter list of 1970, where my mother's name appeared. Page number 59 is the voter list.
Where is this exhibit K? That is your link certificate. Where is that?
At page number 58.
58.
Yes,
No, 58 is a birth certificate.
yes.
That link certificate which you got from your this
Link with my
Mm.
mother, Lordship.
no that Gaon Panchayat or
Gaon Panchayat certificate is at page number 70.
70.
Yes. Lordship, here page number 69 is wrongly tagged with tagged before 70. It should be after 64, Lordship.
which one
Page number 70 is the Gaon Panchayat
you come here
certificate.
very wrong file
He came as witness. This Gaon Panchayat president or secretary, they came as witness.
No, Lordship.
Then you have no link document. We just give you some short relief of bail for some time. But then you don't have anything. The presence of your father is not found, or your grandfather, because you must take lineage from your father or mother, wherever, but that lineage is missing.
There's a copy of Patta in my mother's name, Lordship, page number 63 to 66.
Page,
Page number 63 to 66. Periodic Hiras Patta, which was granted in favor of my mother, Khairan Nisa, who is daughter of late Counsel Sheikh. Counsel Sheikh is my maternal grandfather. My mother inherited my maternal grandfather's landed property and stays there also.
we are unable to read this document. In this
Page number
page,
63 is
page
sorry.
65,
65. Okay.
you have a better copy.
So I can read. May I read, Lordship?
Read the third line, there is a date. I am interested in that date,
Third line.
page 65.
Yes. মই ওপৰত লিখা জিলা ডেপুটি কমিশনাৰে ইয়াৰ
Only the third line, the date,
Third line.
31 March.
মাটিখিনি 31 মাৰ্চ July, in handwritten it is July. 31 মাৰ্চ তাৰিখলৈকে 20 বছৰৰ কাৰণে তলত লিখা ৰাজহ আৰু স্থানীয় কৰত আপুনি শ্ৰী খাইৰন নেছা আপোনাৰ উত্তৰাধিকাৰী প্ৰতিনিধি আৰু চলাভিষিক্ত বিলাকে বন্দোবস্ত কৰিলো।
Because in this Patta, that is the only place where the dates are given. There is no date anywhere else. When is that Patta issued? We don't know. Whether this is
The concerned department has that.
no, whether this is, you see, the requirement is 25,371. That's why if the document doesn't show, it will, we presume it to be post 71 document.
The Lordship, the property is of my maternal grandfathers, and thereafter it is.
But that's okay, but you must
given to
connect,
my mother.
you must connect with your paternal grandfather also. The link is not there.
Grandfather, relating to grandfather, Lordship, translated copy of voter list 1997 annexure 11, page number
This is
60.
again post 2020, post 71 document.
Post 71, Lordship, translated copy of voter list of 1997.
Post 71, 97 is post. The connect is not there. There's a disconnect.
My mother's name appeared in the voter
They're
list.
giving you protection for some time, but this is the
Yes.
only short relief you may get. But Ms. T. Begum, Planet Counsel for the Petitioner. Which page is the opinion?
Page number 54, annexure 8.
Opinion dated 4/8. This is 4/8/2020.
Yes, Lordship, there is some delay also.
What is the explanation for delay?
Delay is, Lordship, para 13 of the petition, Lordship. I have stated. Para
You inherit land and then say you are poor.
Erosion.
I am poor, Lordship.
The 24/12/2020. Past in so-and-so by so-and-so is held in this writ petition filed under Article 226 of the Constitution of India. So the petitioner was declared to be a foreigner post 25/3/1971. Next by the shall the respondents. CGC respondent number 1. A. Verma, the standing counsel for Home Department representing respondent number 2 and 4. Mr. R. Talukdar and government advocate appearing for respondent number 3, and Ms. P. Barwa, standing counsel for respondent number 5. Yes. None appears on call for respondent number 6. The next part, the learned standing counsel for the Home Department was objected to the admission of the writ petition on the ground of delay in approaching the court. Full stop. Accordingly, keeping the issue of limitation open, issue notice returnable in 4 weeks. So requisite extra copies of the writ petition be served on the learned CGC, state and standing counsel for within 2 days. Call for the records. Bill 5,000 to the satisfaction of Superintendent of Police, Border, Bongaigaon. You have 10 days time to appear.
Yes.
And take bail. We are keeping the issue of limitation open.
Deeply obliged, Lordship.
Item 8.
So. It doesn't time. I see.
May it please, Lordship. My lord, on last occasion, your Lordship
Made you uncomfortable
referred to decisions, my lord.
and made you uncomfortable.
2016 1 GLT, page 273.
Yes.
So, my lord, here I want to submit before your lordship. I have gone through the decision. Here I want to submit one thing, my lord, that actually every case is to be looked into from the factual background. my lord. So,
Correct.
in 2016, one GLT decision, my lord, here what happened? The delay was about 7 years, my lord. No, sorry, my lord, 5 years. After 5 years, my lord, so many applications were filed and said that I want to produce some documents. But the documents were not produced and applications were submitted. Applications were submitted without medical certificate. Then also times and again it was granted. And after granting the same, my lord, ultimately tribunal decided that no further adjournment will be given. So, my lord, in my case, my lord, I only appeared for one time, my lord. And my lord, there is a delay only of 1 year, 6 months, my lord.
No, also that you'll have to show there were 13, even despite your non-appearance,
My lord.
travel gave you 13 dates.
My lord, 13 days has been given, my lord. I was not present. Your lordship would be pleased to, that is not available with me, my lord. From record, it will reveal that I was not present.
No,
My
that's
youngest
okay.
counsel, my lord, without
That's
my
okay.
instruction, my lord, filed the petition.
We can only pray that you win elections, and next time when you win the election, change the law, allow us invitation cards, so that after notice, we give you invitation card. There'll be people who will go you respectfully invite you to the court.
My lord, only thing is this, my lord, there is a distinction between case referred, my lord, by my learned friend that 2016 1 GLT 273 and my case, my lord. Here, my case is this, my lord, I appeared once and thereafter I am deviated, my lord. That is due to my
But that
ignorance,
the explanation is not there at all.
my lord.
In this writ petition, there is absolutely no explanation, except for that you went to the MLA said we'll take care.
My lord, what is right thing, my lord? What has happened to me? That I
see-
disclose to your lordship.
No, that's okay. But you see, you
But
went to
the-
a politician. Every politician will give you every assurance, whatever he can, that he will
That is
do
there,
this,
my
he'll
lord.
do that.
But your lordship will consider here, if I openly, my lord, I could have taken some other plea also. But exactly, my lord, what is there, my lord? That I have disclosed. I know that that may not rescue me, but I humbly submit before your lordship. I am before your lordship by filing an application under 226 of the Constitution of India.
Mr.
My
Sheikh,
lord,
Mr. Sheikh,
I am
you,
submit.
before election, you ask a MLA that I want a house of gold. He will say yes.
My lord, that is there, my lord.
Then-
That is there. Every day we are looking into this.
No, absolutely not satisfied.
Citation public.
And even from 22 to 24, even from opinion of 99-22 to 24, you have not said anything.
One GLT
Ah,
273.
7-3
Fine.
on das.
I will.
Huh?
I will.
No, it is then different.
No, yeah.
273.
Mr. Sharma given this reference.
Okay, we'll call for the records. We'll give him we will say that he'll not be deported. And we'll, on receipt of records, we'll consider a prayer for bail.
He's in. He's
My
in.
lord, I am in custody, my lord.
Lordship, let the records.
Let him
come.
remain, let you remain for some days.
Some more days, Lordship, let the records come, Lordship.
We'll examine the records because there's no explanation anywhere. Even from 22 to 24, there's no explanation.
My lord, record will reveal, my lord.
We'll call it. We'll call it.
All right, my lord, I am satisfied that some relief I have got. I am not to go to Bangladesh.
It's okay.
Well, let us the record.
We don't say anything. The only thing is we don't want you to go out with a long face. That's why we are giving you that protection. Yeah, otherwise always smiling man. We don't want you to go with a long face.
But one thing, my lord, outside of my case, my lord, we are fighting this from 1979. That agitation started for 6 years for deporting of Bangladeshi foreigners. Thereafter, tribunals, my lord, Assam Accord. But it is very.
Tribunals existed before that.
My lord,
Don't worry.
Yeah.
Just let me complete
But
the
it
order.
is active after this agreement, my lord, so and so. So, my lord, here I submit before your lordship, even 1,000 Bangladeshi is not government, driven out from this country.
That's okay.
1,000.
That's why we are praying that you become a politician and do something for the state.
Right.
I heard Mr. Abhishek, learned counsel for the petitioner. Mr. S.S. Roy, learned, also heard Mr. S.S. Roy's learned CC appearing for respondent number 1. Mr. A. Verma, learned standing counsel for the Home Department representing respondent number 2 and 3. Mr. R. Talukdar, learned government advocate appearing for respondent number 4. And Ms. P. Barwa, learned standing counsel for respondent number 5. None appears on call, respondent number 6. Next, opinion. Page 36. Ex parte opinion.
Page 37, my lord.
19/9/2022. RPS 177 is held in this declaration, declaring the petitioner to be a foreigner of post 25/3/1971 stream. Next, the learned standing counsel of the Home Department has objected to the admission of this writ petition on the ground that the delay is not appropriately explained. Full stop. Accordingly, keeping the issue of limitation open, limitation and the explanation of delay open, issue notice returnable in 4 weeks. Requisite extra copies within 2 days. Call for the records. Next paragraph. We prepare for releasing the petitioner on bail from the detention center shall be considered on receipt of the records of the tribunal. Next paragraph. However, in the event the petitioner has not yet been deported, he shall not be deported without an order of the court. Next paragraph, the learned standing counsel for the Home Department shall transmit a downloaded copy of this order to the concerned authorities to bring this order to their notice. Next paragraph. List in 4 weeks and on receipt of the records of the tribunal.
My lord, may I pray that after receiving the tribunal's record, my lord, my bail petition will be considered.
We have already said that.
My lord.
It will be considered.
Obliged.
I've said that.
Obliged.
I've said that. We have very less time. We rise. We'll be 5 minutes late in assembling again at 2. Maybe 5 minutes late.
I have the record. Impugned opinion was passed not way back
on 12/6/2019, my lord. On the basis of that judgment, my lord,
No, you see,
opinion, my lord, he has been.
your petition does not inspire confidence.
Yes.
Because of the fact that you make allegations against the lawyer, but you do not do anything against him.
It's my lord. Actually,
Words you are
because of
using
that-
is,
Because of that engaged counsel, my
no,
lord.
that's okay, but you are using words which are very strong.
Yes.
You say that you have been cheated by a lawyer,
Yes.
and then you don't take any steps. That
My lord, I have to know address of the advocate, my lord. He is not a practicing lawyer at Borpeta Bar, my lord. He was engaged, perhaps, my lord, from the Jamiot, my lord. They appeared, my lord. I do not know the address of the advocate, my lord.
that's okay, but
That's
do you
why-
use the word cheat?
Yes, my lord. He has been seated, my lord.
But if you have been cheated,
2-3 dates, my lord, he appeared along with
you
his
know the
advocate, my
meaning
lord.
of the word. Many things we don't know. That's why we are asking.
Yes, my lord.
You know the meaning of the word
Otherwise, my lord,
acquiescence,
Otherwise, my lord, he is.
acquiescence, waiver.
His documents, my lord.
You know the meaning of these words? Acquiescence, waiver.
So, expertise husband, my lord, he will appear before the learned tribunal and
that,
contest the case on merit, my lord, by filing.
You don't get that, you're
written
asking.
statements, my lord. So, my lord, my humble submission before your lordship, my lord, the case may be remanded back, my lord. He will contest the case on merit.
No,
Otherwise, my lord, he is having all the documents, my lord. He has, my lord, he became first voter, my lord, way back in 1975, my lord, along with his parents, my lord. Is that page, my lord? 24, my lord, 23, 24, my lord. 75 voter list, my lord. He has been punished, my lord. Today, my lord, 73 days, my lord, in jail, my lord. Detention center, my lord, at Matia, Gwalpura. For his fault, my lord, he has already punished. Got the lesson, my lord.
So it's not, you've not made out a case for. You're not made out a case for bail. You just say you're not to be deported.
In fact, my lord, the inquiry officer's report, my lord, which is at page blood 752, my lord.
That's
In the
okay. You
inquiry
got
report
notice.
also, my lord,
Deported
the
case.
You got notice, you contested the matter,
Yes.
you even filed an application for.
Otherwise, my lord, the learned tribunal, my lord, has not committed any wrong, my lord. He has
That's why
rightly
you're not
passed his
giving a
opinion,
bail,
my lord.
because you've been
He
secured
has
after.
no option, my lord. Otherwise, my lord,
Yeah, because you've been
Actually,
secured
my
after a
lord,
long time.
This is a devoter case, lordship, please. does not conduct the inquiry, Lordship, did not conduct the inquiry.
My humble, that is why my humble submission before your Lordship, my lord, the matter may be remanded back, he will contest the case on merit, my lord. Otherwise, my lord, in the inquiry report itself, my lord, he is having a link, my lord, with his parents, my lord. In column 8, my lord, whether father is registered as an elector of any constituency in India, yes or no? Yes. If yes, serial number and part number of so and so. Paragraph number 9, my lord. Known and name of constituency, 47 number Sharvok LSC, 1965 voter list, my lord. His father's name, my lord. Which is at annexure A, my lord. I have annexed. Only fault, my lord, because of the advocate, my lord. I again submitted before lordship, my lord.
No, no.
Otherwise, my lord, he is having all
don't
the.
blame the lawyer. Behind his back, we may say so many things,
Yes.
but you do not have the courage to make him a party and then say in his presence.
I do not know the address of the name and address of the advocate. That is why, my lord. He is a rustic man, my lord. He
That is
cultivator, my lord. He does
that
not
is-
know the
that
law
is
of the land, my
strange.
lord.
That is strange.
Yes. Otherwise, he was regularly appearing before the tribunal, my lord.
No, we've seen the records.
Yes. In
Nothing
the
about
opinion, my
regularity.
lord, itself, my lord, 4-5 dates, my lord, he appeared, my lord, along with his advocate. Thereafter, no advocate, no petitioner, my lord. Otherwise, he is saving all the documents, my lord. Once last chance may be given to him, my lord, in the.
No, we'll hear the matter. If we
Internet
have the
of justice,
record,
my
we'll
lord.
hear the matter. But
Otherwise, he is having all the documents, my lord. He has, he has been registered as a
you
voter,
see,
my lord, way back in 1975, along with his parents, my lord, also, my lord.
you have seen the records.
No, my lord.
You've not seen the records.
I'll see, my
You
lord.
see it. We'll hear the matter. Well, we are not giving you, we are not releasing you. We are merely saying that not to be reported. It doesn't inspire confidence. Making allegation is very easy.
Yes. It is fact, my lord, actually, my lord. My humble submission before lordship,
No,
my lord.
no.
He does not know
Look
the
at-
name and address of the advocate, my lord.
Don't say that.
That advocate was engaged by the, perhaps, my lord, by Zamiot, my lord.
Don't say that. You see, you have not seen the records.
I have not
You
seen.
don't know the contents of the petition.
Yes.
Then don't make that statement.
Yes. See, my lord. Next
Statement
week, my
must be
lord.
backed with some sort of conviction. That conviction is missing. You look at the petition. The first petition says that the petitioner wants to take a pro bono legal assistance.
Yes.
That means you are not even engaged him. The lawyer has appeared. Look at the petition. Show him that petition.
My petition, my lord.
No, your petition filed. Show him that first petition.
Yes.
First petition says that I want to take pro bono assistance. So a lawyer comes and files an application that the petitioner wants to take pro bono assistance. What does it mean? Now you say that you appeared with your advocate
Yes.
before the tribunal. So without knowing your lawyer, without knowing his address, he goes from Guwahati and appears in that tribunal.
Actually, but that advocate was
We
engaged by
don't
the-
know. We don't know. You see, we are just asking you questions. I personally don't know the lawyer. But
I
look
must-
at the petition. The Wakalatnama is of Guwahati. That's why we are saying it. Otherwise, a lawyer in Barbeta or somewhere else will not use a Guwahati Wakalatnama.
Yes, my lord.
So you come to Guwahati, you take the lawyer to Barbeta. Is Barbeta right?
Yeah, Borpeta, my lord.
Huh?
Borpeta, my lord.
Barbeta. You go to Barbeta and you claim that you don't know the lawyer.
Amar Borbia and S.
He is a male. He's not Parda Nashin,
Yes.
that he goes with a lawyer and does not see him.
He's my lord. He's not the advocate.
And without knowing you, how do you go? How do you travel with him? Unless you say that this mailman is a Parda Nashin male.
He saw the advocate, my lord, but
he goes to
but
the,
he
goes to
does not
the,
know the name and address of the advocate, my lord.
that is very good.
Yes, my lord. He is not an advocate of.
Not a good case for bail. If you don't know anything,
Oka Thomas says that
not a
he
good
is
case
his
for
party,
bail.
my lord.
If you don't know anything, it's not a good case for bail.
Otherwise, my lord, he is having all the documents, my lord.
No, we don't know. You do not go before the tribunal. In tribunal, you say so many things.
That is why
3 months
my
you-
whole submission
three-
with lordship case
3
will be
months you-
remanded back. He will contest the case, my lord. One chance
No,
may
no.
be given, my lord.
We will hear.
Already, my lord,
then we'll say.
because of his fault, my lord, he has got the lesson, my lord. Today, my lord, 73 days he is in detention, my lord.
Hearing on peaceful.
You say on merit, we are hearing you.
Yes.
We are hearing you right now. You tell on merit.
It will be record, my lord, next week, my lord. Next week.
Both sides are represented. Mr. G. Sharma, and standing counsel for the Home Department, has produced the record of the record of the Ordinance Tribunal 9th Borpeta. Of the no, within the opinion impugned, this repetition is passed. Post on. Next para, as the opinion is an ex parte opinion, we propose to hear the matter on the next date of listing. Next para. In the meantime, if the petitioner has not yet been deported, the petitioner, namely Manjur Islam, alias Manjur Rahman, who has been apprehended on 2/9/2024, pursuant to opinion dated 12/6/2019, in FT 9th within bracket capital BPT bracket close case number 8170/2018, and presently lodged in the detention camp at Matia Kualpara, shall not be deported without the order of the court. Next para. Accordingly, issue notice returnable on 27/11/2024, without requiring the petitioner to take any postal steps. However, requisite extra copies of the writ petition be served on the learned on Mr. S.S. Roy Leonard CGC for respondent number 1. Mr. Election Commission was there.
Election.
A.I. Ali.
Yeah.
Mr. A.I. Ali, standing counsel for respondent number 2. Mr. G. Sharma, and standing counsel for respondent number 3 and 6, and Mr. H.K. Hazarika, and government advocate appearing for respondent number 5. There is no representation from respondent number 4. Post on. List on 27/11/2024.
Lordship LCR may be kept in the custody of the court, Lordship.
Okay. Has this he has produced it also, and he has purpose of the said record is kept in the custody of the court. The court master shall tag it with the record and make a note in the note sheet. List on so and so. Acha, next date you say the learned standing counsel for the Home Department shall transmit a downloaded copy of this order to the detention center, detention camp, Matia Kualpara.
Obviously.
time being item 2, 3, and 4.
Wait, please, Your Lordship. These are all expertise judgments, Lordship. May I pray to take up, Lordship, 4692 first, Lordship, the item number 3, Lordship.
Yes.
In this case, Lordship, the petitioner's father was earlier declared within the stream, Lordship, and he was directed to register his name.
Where is that?
That order is, Lordship, page 29, annexure 8.
And how do you connect yourself to your projected father?
Lordship, thereafter petitioner father filed an writ petition, and after that he was directed to appear before the registering authority, Lordship, and thereafter he registered his name. Thereafter again notice received by the petitioner's father and petitioner. Those two notices were under challenge before this court, Lordship. During pendency of the proceeding before this court, Lordship, learned tribunal declared him foreigner, Lordship. And from the said judgment, we found that there were 5 cases disposed of ex parte, including my wife and my mother also, Lordship. So these 3 writ petitions, Lordship. Page 33 is the relevant portion, Lordship. Second paragraph. Accordingly, this reference is disposed of against Muhammad Abul Kalam, son of Muhammad Hafez Ali, care of Muhammad Sorumaina Begum, village Udainagar, ward number so PS district Bhulagat, Lordship. Permanent address village Singimari Moja Laukwa, PS Rupohi Hat, district Nagaon, Assam, is declared foreigner of between 1st day of January. Anwar to police.
এডিটিং কল করছিল না, রেকর্ড কল করছিল, বাকি হেৰি কৰা নাই।
Is pursuant to the direction you have registered yourself.
Yes, Lordship.
Where is that?
Page 37, annexure 10, Lordship.
It's 37.
Original is
You have
page
declared the names of your the petitioner here.
No, Lordship, only Abul Kalam.
No, but you are required to disclose the name of all your family members. No.
No, Lordship, that is only 1 page document, Lordship. Page 38 is the original. And page 37 is the type copy, Lordship. Lordship,
What is the
these
name of
family members were declared. Name, husband, wife, Lordship, Ambia Khatun, Anwar Hussain, Akhtar Hussain, Manjuara Khatun, Moina Begum. In the document itself, Lordship. Separate documents not enclosed, Lordship.
Okay. Now, who are the petitioners here?
Anwar Hussain, Anwara Hussain and Ambia Khatun, Lordship.
Anwar Hussain, second man.
Second, Ambia Khatun, Anwar Hussain's mother, Lordship.
Ambia Khatun's mother.
Yes, Lordship.
And
his wife also. She will prove her linkage through her father, Lordship. But Anwar Hussain will prove his linkage through Abul Kalam, Lordship.
now, where is this? Where is the first opinion? Where is the second opinion?
First opinion to register the name. That is at page 33, direction part, Lordship. 33 is the relevant portion, Lordship. Page 34 is the relevant portion, Lordship.
Okay. Now, where is the first opinion? Where is the second opinion?
First opinion to register the name. That is at page 33, direction part, Lordship. page 33, Lordship. Tribunal's order, Lordship. In second paragraph, he was declared as foreigner of between 1st day of January 1966, but before the 25th day of March 1971 street.
This is opinion dated
Judgment 16/5/2016, Lordship. Page
16/5/16.
Yes, Lordship. Annexure 8, page 29.
Okay.
Thereafter, we moved an writ petition before this court, Lordship. That is
Yes.
Annexure 9, page 34. WPC 5174/2016. And on interim measure, Lordship, a direction was passed to register his name, that is page 35. Last paragraph,
Okay.
in that view of the matter, we are of the view that registering authority of Nagaon was not justified in not accepting the prayer of the petitioner for registration. We accordingly direct. Thereafter, Lordship, this writ petition was disposed of. We registered our name by Annexure 10, then Annexure 11, Lordship. This writ petition was disposed of on 22/5/2018, page 40, Lordship.
Okay. Now,
There are-
second reference is against Abul Kalam.
Yes, Lordship, that is Annexure 12, page 42. We have received notice, Lordship. This notice in respect to my father, Mohammad Abul Kalam, who was declared within the.
Yes.
And second notice, Lordship, that is page 44, Mohammad Anwar Hussain, that is the present petitioner, Lordship. These two notices were under challenge in WPC 5377, page 46.
Okay. Let me give him bail.
Yes, yes.
Call for the records are already
Records were
done.
already called, Lordship. May I pray to Lordship give one chance to appear the petitioner before the learned tribunal, Lordship, and to prove his case, Lordship.
We will examine that.
Yes.
We are giving you bail for the time being.
After High Court's opinion,
you-
Lordship, we
no.
applied for the certified copy from the High Court's LCR, Lordship. Then only we came to know that the ex parte opinion was rendered in favor of 5 persons, Lordship. That page 54, your Lordship will find. So accordingly, we came to know that including petitioner, the other two writ petitioners were also declared foreigner, Lordship, ex parte. But in those cases, we have not received notice, Lordship. I have seen the LCR, Lordship. Page 2 shows an order dated 14/3/2019. On a conspicuous place, Lordship, the notice was hanged, and thereafter it is served as presumed to be served, Lordship. Into the same order. In all the three cases, tribunal passed the same order, on same date, similar order, Lordship.
Look at this.
গোটেইকেইটাই notice receive কৰা নাই।
Yes, Lordship.
They say that you read it, then you'll understand. And below that. Huh.
সম্মানপূৰ্বক বিনীত নিবেদন এই যে বিদেশী ন্যায়াধীকৰণৰ জাননীত উল্লেখ কৰা ব্যক্তিজনক ঠিকনা মতে বিচাৰি যাওঁ, উক্ত স্থানত ব্যক্তিজনক বিচাৰি পোৱা নগল, সেয়ে তেওঁ থকা ঘৰৰ বেৰত ওপৰত উল্লেখ কৰা আসামীগণৰ সাক্ষীগণৰ সাক্ষাতত জাননীৰ নকল কপিটো লটকাই জাৰি কৰা হ'ল আৰু মূল কপিটো মহামান্য আদালতলৈ প্ৰেৰণ কৰা হ'ল।
So this report is of 11th and the witness is signed on 8/3. In the service report, it doesn't say when he went there. But on one day, if the family members are not there, can service like that be made? So they'll have to arrive at a finding that he has left the place.
Lordship.
Is it proper?
No, no. Witness signed 8/3/2019 and Lordship report was made 11/3/2019.
It doesn't say when he went there.
Yes, Lordship.
It doesn't say when he went there. And number one, there is one part. The second part we are more interested in understanding. And this
Yeah.
ordinance tribunal order, supposing somebody is not found in a place, can recourse to alternative service, this service by hanging be made?
Lordship. As per Ordinance Tribunal Order 3F, Lordship.
When he's changed his address.
3-5 there.
Nothing to do.
Because it's not the case the adult family member was found and he refused to accept.
Yes, Lordship. If the proceeding has changed the place of residence.
That's not the
or
case.
Yes, Lordship. That intimation to be.
It does not. It does not comply with B and C and D. And D is that the adult family
Yes.
members refuses, then the process will be reported to the forest tribunal.
Lordship.
So they have taken recourse to G.
Where the proceeding or any adult member of his or her family or not found in the residence, a copy of the notice shall be, yes, Lordship. Pasted in a
So that also is not written. No adult member of the family was available.
Lordship. Advocate of this.
And then come to I.
Lordship.
If no person is available or willing to be a witness to service or refuses or so and so. Oh no, this will not apply.
Then fine, a fine certificate. of- এখন না পরে না আসলো আমি না
Mr. Sharma, as the petitioner, this, what do you call him? His name is Anwar Hussain.
yes
He was declared to be a foreigner of 1666 to
No,
1971.
he was declared post 71 stream for his Lordship.
No, in the first opinion, it is between that stream and therefore he got
His
registered.
father Lordship, Anwar Hussain's father Lordship. Abul Kalam.
So we give the petitioner an opportunity to contest.
Yes, Lordship. Anwar Hussain has to establish his link with Abul Kalam, who was
Yes.
declared foreigner in
Yes.
the stream Lordship.
Then they will do, but the service report.
That was already, your lordship has discussed in earlier round of litigation, that is WPC 5377, page 46, lordship.
Page
That page 46, lordship. Your lordship.
in which
just-
writ petition?
In this petition itself, 4692, lordship. Annexure 14, page 46.
46.
These two notices were under challenge by the petitioner, including lordship his father in WPC 5377. That was disposed of, lordship, after going through the lordship has pointed out that you were already declared foreigner. Thereafter, we obtain certified copy from the LCR of this High Court Lordship. Page 47, your Lordship's order. And page 48, in so far as the petitioner number 2, namely Anwar Hussain, is concerned. LCRs, I need to order this.
48.
Okay.
Your Lordship may remember that at the time of arguing that matter, your Lordship has pointed out from the LCR that you were already declared foreigner.
Okay. Mr. Sharma, we allow the petitioner to live with the tribunal within a specified time. But this is 4692. But Mrs. R. Chaudhary done it. Counsel for the petitioner. Also heard Mr. G. Sharma done as standing counsel for the Home Department, representing respondent numbers 2 and 4. Mr. H.K. Hazarika, done government advocate, appearing for respondent number 3. And Mr. T. Deuri, counsel appearing on behalf of Mr. A. Ali. Done it. Counsel for respondent number 5. And Mr. S.S. Royal and CGC appearing for respondent number 1. So there is no representation, none appears on call for respondent number 6. Next para. The ex parte opinion against the petitioner on 27/4/2020 by the Foreigners Tribunal, by the learned member, Foreigners Tribunal, Jorat, in FTG /1781/11, by which the learned tribunal, by a common order, declared the petitioner to be an illegal migrant of post 25/3/1971 stream, is assailed in this writ petition filed in Article 226 of the Constitution of India. Next paragraph. The case projected by the petitioner is that his father, Mohammed MD, Abul Abul Kalam Kalam, was declared as a person who has entered into the country from Bangladesh between 1/1/1966 and but before 25/3/1971, and accordingly he was declared to be a foreigner, but entitled to benefit of Section 6 capital A within brackets numerical 3 bracket goes of the Citizenship Act 1955, and he was directed to register himself before the registering authority of the district in which he ordinarily resides within 30 days. Next paragraph. There was some delay on part of the petitioner to approach the registering authority. No, sorry, the father of the petition, projected father of the petitioner to appear before the registering authority. And therefore, his projected father approached this court by filing WPC 5174 of 2016. And this court, by an order dated 7/9/2016, directed the registering authority, Nagaon, to register the petitioner as a foreigner belonging to the 1966-1971 stream. And 15 days time was granted from the date of the order to appear before the registering authority. Full stop. Next. Petitioner was registered under Section 6A of the Citizenship Act before the registering authority on 21/9/2016. And informed Roman 25 XXV Roman 25 dated 21/9/2016, it is projected that the projected father of the petitioner had declared the name of his family members stop. Accordingly, on registration, WPC 5174 of 2016 was closed on satisfaction. Stop. In the meanwhile, next para, in the meanwhile, the projected father of the petitioner received a notice of reference against him before the Foreigners Tribunal, Jorhat, being FT case number FT capital G oblique 1784/11. As a common opinion dated 27/4/2020 was passed by the Foreigners Tribunal, Jorhat, in connection with the petitioner, namely Anwar, ANOWAR, Hussein, SUS, comma. The court permitted the petitioner to withdraw the writ, which said WPC 5377 of 2019 with liberty to assume the opinion had rendered against him. Full stop. In respect of the prosecuted father of the petitioner, comma, the court had directed that the petitioner would be at liberty, that the prosecuted father of the petitioner would be at liberty to produce the certified copy of the relevant documents and as well as the earlier orders before the learned foreigners tribunal, Jharati, so advised. And accordingly, the writ petition was disposed of. Full stop. However, the this Abul Kalam also, the opinion is there. It's a
Abul
comment.
Abul Kalam Lordship LCR at that relevant point of time.
It was not there.
Not there, Lordship.
Okay, okay.
So paragraph 7 was dictated in the earlier order, Lordship.
Full stop.
Only Abul Kalam was declared within stream foreigner. Abul Kalam was declared foreigner lordship within the stream lordship.
No, but why in the second
Subsequent-
reference, what has happened? That's what I'm asking.
Oh, yes, yes.
Liberty was granted to the petitioner by paragraph 6
So
and
that is still pending.
that Lordship under inquiry, Lordship. The petitioner was directed to inquire about that proceeding, Lordship. That we are not informed anything about.
Okay.
Whether final judgment was passed or not.
Okay. Next paragraph. The challenge to the ex parte opinion dated 27/4/2020 is opposed by the learned standing counsel for the Home Department on the ground that there was an ordinary delay in approaching the court. And it is submitted that although the notice was hanged at the press however, the report by the concerned police personnel, the date of service is not recorded, and the report is of 11/3/2020.
Lordship,
No, there is
I think 3 witnesses, Lordship.
three.
Islam Hussein, Muhammad Siraj Ali, and Muhammad Idris Ali.
There's 8/3/2019, huh? And the report is dated 11/3/2019. Make it 3 witness. In the said opinion, in the said service report, It has not been recorded as to whether the petitioner had permanently left the place of residence or he was temporarily absent. Full stop. There is also no note that any attempt was made to serve the notice of the proceedings on any adult member of the family. And it is also not recorded that any family member of the petitioner was present and refused to accept the process. Therefore, on the first attempt to serve notice on the petitioner, the police personnel assigned to serve notice had taken recourse to section 3(5) within bracket G without making any attempt to serve notice as envisaged under section 3 within bracket, not section, it will be para 3 within bracket 5 within bracket B and C. Next one. Therefore, what is of the constituted opinion? Whereas the petitioner has been able to demonstrate that his projected father was declared to be a foreigner between 1966-1971 stream. Petitioner should be given an opportunity to contest the proceeding by filing his written statement and contest the matter as he may be so advised. Full stop. Accordingly, in view of the discussions about the ex parte opinion against the petitioner, namely Anwar Hussain, is interfered with and set aside. Resultant, the petitioner is given an opportunity to contest the proceedings of case number FTG 1782 of 2011, arising out of SP inquiry number 278 of 2010. No, sorry. Appear before the Foreigners Tribunal, Jurat, within last day of November 30.
Lordship.
You had sufficient time then
Lordship.
between 3/11/2024 and by producing a certified copy of this order, await for further directions of the said tribunal. Next paragraph. Within 10 days from today, the petitioner shall also appear before the Superintendent of Police within bracket border, where Golaghat,
Yes, Lordship.
and furnish bail of rupees 5,000 with surety with all those conditions. then it is made clear that on the failure of the petitioner to appear before the said authority within the time allowed, the order of bail shall stand lapsed by a fix of time. Next para. Written statement also on that day
Yes.
on
Lordship.
appearance.
Yes, Lordship. Some more days may be given as because LCRs are here, Lordship.
Acha. Okay, on
In the
appearance, the
month of
petitioner shall be at liberty to make an I don't say anything. Listen, appearance is it's all it's allowed. Revision stands allowed. In terms as indicated above. So there should be no orders to cost. Then in this Fatima Khatun, there's
Lordship,
4690.
on or before 30th November or 9th December, Lordship. On or before 30th December or 9th
No,
December.
13 November, 13 November.
13 November, Lordship. Can it be on 9th December as because all the LCRs are here, Lordship.
No, even without that, we are giving you 10 days time to take bail.
Bail
And
we
then
can
you
take,
appear
Lordship.
before the tribunal. If there is no record, it will-
Written statement, Lordship.
no, if there is no record, the tribunal cannot proceed.
Lordship.
You will get a date.
Lordship.
And this Fatima Khatun, who is she?
Fatima Khatun, Lordship, wife of the Anwar Hussain, wife of this Anwar Hussain, petitioner.
Wife of
the-
Anwar Hussain. Then
Yes,
how does she
As it is a
project
common
herself?
order, Lordship.
No. But that how she's
Lordship, in para 12, page 9, we have mentioned that while obtaining certified copy of Anwar Hussain, we
no. How does she connect herself to be a daughter of an Indian citizen?
Lordship. That is voter 65, voter list, page 15, annexure 1. Her father name is serial number 275, A. Hakim, Lordship.
Okay, here just there's only one paragraph to be added. You see that
1970 voter list is also there, Lordship.
rest of same, everything will be same. As the initial stage, her submission would be that the learned counsel for the petitioner submits that while applying for a certified copy of the common opinion, dated 27/4/2020, in respect of Anwar Hussain, who is the husband of the petitioner, against whom case number FTG 1781 of 2011 was registered. It was noticed that the said common opinion was also rendered against the petitioner in who is the proceeding in case number FTG post of 1782 of 2011. And it is submitted that no notice was served on the petitioner. Here the name of the petitioner will change. She is Fatima Khatun, alias Fatima THATOON. One is UN and his OON. Rest will be same. Then third is
Mother of Anwar Hussain.
4693. This is the name of the petitioner is Ambia AMBIYA Khatun KHATUN, alias Ambia AMBIA Begum. Here this second statement will be there. On applying, she came to know party opinion. Case number FTG 1783 of 2011.
I'm deeply obliged.
Item 9.
What is your best document?
My lord.
What is your best document to connect you to your projected parents?
My lord, my elder brother's reduce as DW, himself as DW2. Can we see 76? Page 76.
Your brother came and deposed for you, right? Yeah, your brother came and deposed for
Yes.
you.
Yes, my lord.
Where is the proof of identity of your brother?
My brother's name is appeared in the voter list of 1977, along with his
Name anybody's name can appear, but what is the document to show that he's your brother? Or how does the brother prove that he's the son of so and so? Any document to show that your brother is your brother?
My lord. Can we see page?
What is this? I can borrow your name and say that you are the earlier, you're the brother. That doesn't create relationship.
He stated that petitioner is my sister, younger sister. Kindly see page 89, ma'am.
Yes.
Page 89. Naushad Ali, his elder brother, along with
No, don't show us the voters list. Any other document to show that he's your elder brother? Voter list does not create relationship.
No, my lord. And another linkage document is here is contract certificate at page 101. But that document.
The witness will come to prove it.
Yes, true.
You know why we are asking so many questions about your father? Your brother doesn't even know when the mother expired. Can it be imagined that a son does not know when the mother expired? He's a 54-year-old man.
My
Doesn't
lord,
know when mother expired.
he also stated
Can-
here
can-
that when his mother was expired, then he was 10 to 12 years. He was 10 to 12 years old.
He will remember more. They'll remember more because they miss the love and affection. But then the story doesn't match. You were 54 years.
My lord.
Correct. Now you say that uh, when your mother died, you were 12 years old. That will make you were 12 years old. That will be how much?
My lord.
54 minus 12 would be, sorry, this. In 2017, you were 54. That means date of birth would be, year of birth would be 1953. You were 12 years old. That means 1965. Your mother died. And you say your sister is 31 years old.
31 years old at the time.
But then to make up the story, you say that your father married for the second time.
Yeah.
Then your story doesn't match.
Here, his mother name is his mother. Rohitan. And his stepmother name is Nurhan. When he was 10 to 12 years old, then his father entered into marriage with Nurvan.
Yes.
Where is your written statement?
My lord, written statement.
In your written statement, did you?
At page 33.
Which page is the opinion?
Opinion is at page 82.
82.
82 maybe.
How do you explain the delay of 5 years in approaching this court?
My lord, the lady was poor lady, my lord. I have stated that para 7, my lord, in my petition. Page 7. Page 7 at para 7.
Page 7.
Page 7 at
Para?
para 7. This is a common paragraph, lordship, in every petition.
Nowhere you have stated that your husband has died. It is only in this writ petition you say that your husband has died. In your examination, you say that you live with your husband. In your statement, you don't say that your husband is deceased.
The petitioner informed me, my lord.
Look at this statement. You don't say the husband is deceased. In your written statement, you don't say anything about your husband. And now in this writ petition, you say that the husband has died.
My lord.
In your statement, you don't know what is the age of your father.
My lord, here only in the inform order, only age discrepancy of her father.
That's okay. When did your husband die? Five years is not a good ground to condone the delay. We may not give you interim protection of bail.
My lord, financial hardship, my lord.
We cannot give you interim bail then.
Yes, she had 4 children, 3 daughters. They have already married, and only son is minor.
If statement doesn't match, the statement doesn't match, we are not inclined to give you protection or bail. You are 34 years old. You say that your three daughters, three children are already married. Your husband is dead. Date of death is not given. If the children are married,
She was married at the age of 16 years. Now she is 42 years old. What?
don't do those
Right.
arithmetic. We are far better in arithmetic than that. In the writ petition, you say your age is 34 years. So don't do those calculations.
My lord, may I be allowed to withdraw this petition to file a fresh one?
You know, good things are put to vote. Here we put this good thing to laugh. Now, how many of the your friends behind you are laughing? That will tell us. Don't do that. You make a mockery of the system itself, and in the process, you downgrade yourself to a man of no substance. Don't do that. You find a division bench taking up the matter. Don't let us go with an impression that the law is appearing in the division bench. Or like that. Don't do it. Be prepared. Do this arithmetic at your home. And you know the bench. When we read it minutely. And then you don't think those smile and laugh will help it. It downgrades your standard. And we feel pity for it. We are laughing not out of fun, because of that pity take on you. Don't do it. Ultimately, you'll have to come to this court and take orders. You see, when you go to your bar, you take tea and discuss about the judges. Here also, when we sit, we discuss about you. So it is not only one bench you are antagonizing. You're making a story of yourself in the entire bench. When we at least when I take tea, I discuss. I'm not saying about my brother, but yes, when I feel pity with submissions like this, I tell my few of my friends, my brothers in the bar. And when the comment comes to, then you retaliate by saying that the judge was unreasonable. You're inviting it on yourself.
I take pardon.
This is item 9. On certain submissions of the learned counsel for the of Mr. P.A. Ahmed, learned counsel for the petitioner is found inconsistent, he prays for allowing him to withdraw the writ petition to approach again. All the respondents are represented. So prayer is allowed. The writ petition stands dismissed on withdrawal with liberty as prayed for.
Item 10.
The appeal order is at page 112, Lordship, and the hearing. And my. Lordship,
To connect you to your
kindly
projected parents.
Page 68, Lordship.
58.
68 is the voter list of
No,
my
apart from voter list, how do you
Yes.
show?
Lordship. Apart from voter list, you have brought into record one Panchayat certificate, Lordship. That is at page 102, Lordship.
103.
102.
Panchayat people came, they got
The-
103 you are showing us.
103. Yes, Lordship.
That is not good. You know the reasons why.
Most probably because of the state emblem, Lordship.
Yes.
And this is not part of the
Any other document?
prosecution.
Any other document you have?
Any other document, Lordship, the father reduced as DW2.
He came.
Yes, Lordship, he came and he reduced evidence.
Okay. Then we give you.
And
It's
that
okay.
is at page 61, Lordship, the cross.
It's okay. We give you protection then.
Lordship.
Mr. Sharma, we give you protection then. Your father has come. Had Mr. Zaid Hussain, learned counsel for the petitioner. Also heard Mr. S.S. Roy, learned CEC appearing for respondent number 1. Now Mr. G. Sharma, learned standing counsel for the Home Department representing respondent number 2 and 6. And Mr. T. Deori, learned counsel appearing on behalf of T. Pegu. Mr. Sorry, T. Pegu, learned counsel appearing on behalf of Mr. A. Ali, standing counsel for respondent number 3. And Mr. H.K. Hazarika, learned government advocate appearing for respondent number 5. First of is none appears on call for respondent number 4. Next one. The where is the opinion? Which page?
Opinion starts from page 112, Lordship.
Opinion dated 25/3/2021. What is the delay? Why the delay?
She was actually very poor lady. She is actually living by doing household works in others' house. Lordship. And page, I have tried to explain, Lordship, that page 22. And totally layman, Lordship. That is the only reason. And when the drive started, then only they could realize, Lordship, that is different, Lordship.
Okay. Passed by the learned member, Foreigners Tribunal number 2, Kamrup at Boko, is assailed by filing this repression under Article 226 of the Constitution of India. Mr. By the said opinion, the petitioner was declared to be a foreigner of post 25/3/1971 stream. The issue notice returnable in 4 weeks. Requisite extra copies of the requisition be served on the rest of the order is same. Bail 5,000 rupees to the satisfaction of Superintendent of Police within bracket border, Kamrup, Amingaon. We shall appeal within 10 days. Within 10 days. We make clear that if the petitioner does not appear and take bail within the time allowed, the order of bail shall stand lapsed by effects of time. List out of 4 weeks on receipt of records of the tribunal. 10 days time to take bail.
Lost. Duly obliged.
No, right. 11. Yes, what is a good document, best document to connect you to your parents?
82, my lord.
Hmm?
Page 82, my lord, and accept
82.
8, my lord.
No, don't show the voters list. Any other document to connect?
No, my lord, there is no other documents except the deposition made by the paternal uncle of the petitioner and one Gaubura, my lord, as DW3, my lord.
Paternal uncle, was it there?
Yes, my lord.
As voters list in your, along with your father?
Yes, my lord. Page 89, my lord.
89.
Yes, my lord. 80.
Yes.
My lord, last name, my lord, Mahmood Ali. He is a DW2. And my father name is Ismail Baksha Mia, my lord. Serial number 388, my lord. Third one, my lord. My first one is my grandfather name, my lord. My grandmother, my father. Last name.
Which page is the opinion?
119, my lord.
Mr. Sharma, we are giving protection then.
Yes, Lord.
Same order, opinion dated 28/6/2024. That's the name of the council. Not. Mr. K.M. Hassan.
Yes, my lord.
General Counsel for the platform. So this is Roy, CGC for respondent number 1. Mr. T. Pegud and Counsel appealing on behalf of Mr. A.I. Ali, standing counsel for respondent number 2. Mr. G. Sharma and standing counsel for the Home Department representing respondent number 3. Article 226 of the Constitution of India. This for the said opinion, the petitioner was declared to be a foreigner post 25 3/1971 stream. Suppose bail 5,000 for the satisfaction of will appear within 10 days and take bail before whom?
Lordship,
Superintendent of Police
border Kamrup.
within bracket
Kaminga.
border Kamrup. Amingaon. 5,000 diameters. On failure to appear, bail order will stand lapsed. 10 days time to take bail. Other matters, motion matters will be listed in a day or two. Admission matters would be adjourned. Motion matters You see tomorrow, day after tomorrow, or tomorrow and day after tomorrow. Or tomorrow, so tomorrow. Motion, day after tomorrow, I say. Motion we are taking up tomorrow.
Yes, Lordship.
The day after tomorrow is a holiday. I have to.
Yes, Lordship.
Okay. You're rising for a single bench. Yes.
Lordship, I was directed to take the CD, Lordship. For some reason, Lordship, they could not produce the CD tomorrow. I mean today. Let it be on Friday, Lordship.
Friday is a holiday.
Yes, Lordship. It's a holiday. On last occasion, Lordship, then let it be on Monday, Lordship, on 18, Lordship.
18th.
Lordship.
Okay, one day you'll have to suffer.
What is the last order of your lordship? Kindly have a look once, madam. There was this possibly a direction that scan copy or something like.
Yes, I remember that.
Yes.
So we created that direction.
Yes, yes. I
If
have
CD
that.
can't be given, then scan copies.
Lordship. Lordship, some protects, some Lordship miscommunication in between, among themselves has occurred. Therefore, Lordship, IO could not produce it, Lordship.
It's
You
okay. But these people are not under the PRS bill. They have harrowing time.
Lordship.
They have difficulties.
Lordship on,
I'll satisfy on
And
Monday,
the
Lordship.
pressure on the lawyers will be more. That is more important.
and one granted, that's a more in the.
No, I understand that. I understand that. I had been once there. Those days I have not forgotten.
That Lordship, because Lordship,
No, it's
earlier
okay. Explanation is
there.
we accept it. May mishap happens, but the anxieties of the petitioners is more.
I understand.
They face these difficulties.
Lordship, there is an interim prayer, at least some protection till Monday. No, Lordship,
Those makes things very difficult. You know that.
on Monday.
Because lordship is also sitting, Malor, in this division bench, then again coming again.
No, that is the difficulty.
Yes, Malor, that is it. We can
The-
come anyway, we have no
The
issue.
temperament
Yes, yes.
has to change from foreigners to bails. Okay, but this time please ensure that
Sure,
the CD
sure.
comes. Okay. All sides are duly represented. No, don't say all sides, say both sides are duly represented. Mr. M. Hallowell, and standing counsel for the CBI,
Special
submits
PP.
a special PP
Lordship.
for the CPI. Submits that due to some communication gap, the case diary or scan copy thereof could not be produced today. Full stop. Next paragraph. The Mr. W.R. Mehdi, learned counsel for the W.R. Mehdi, and Mr. H. Chaudhary, learned counsel for the petitioners, submitted. There's some urgency in the matter as the petitioners are not on interim bail. Next paragraph, the learned standing counsel, the special PB for the CBI shall communicate to the respondent authorities to ensure that the case diary or scan copy thereof is produced without fail on 18/11/2024. Next paragraph. On non-production of the case diary or scan copy thereof, liberty is granted to the learned counsel to the petitioner to make a prayer for to renew their prayer for interim bail. Next paragraph, list on 18/11/2024.
This time possibly it will come, my lord.
No, actually some miscommunication among them
Sometimes
staff only, Lordship, nothing else, Lordship.
we have to go,
Yes,
we have to accept the case.
Your last 24, possibly the CD was before this court, possibly, my lord.
Last of the jন্য আসেন। Last time was there. Okay, please ensure. Okay.
Pronouncement of judgment oblique order. Item 1. WPC 5587/17.
The petition is dismissed. Item 2. In this case, we have held that the resignation letter dated 10/10/2012, which has been produced before the court, is a fabricated document, and therefore court is not inclined to hear the petitioner. Accordingly, this revision petition, question application is dismissed. There's no impediment for the trial court to proceed with the trial of CR case number 2104 of 2016. Oh, in the last order, Mr. Sharma, you are also there in the last matter.
Yes, in
Item 5. So along with the counsel for the petitioners, I've said W.R. Medhi, Mr. H. Chaudhary, in the first item, adjournment item. There in item 5, Mr. D. Sharma is also there.
Yes.